Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Edward Elgar Publishing Limited. It's an important book for anybody involved in jurisprudence. The title of the book is Facts and Norms in Law, with the subtitle Interdisciplinary Reflections on Legal Method. Now, as all of you who've studied, certainly at the LLB, will know that jurisprudence and legal method and legal theory are very, very important, or considered very, very important, as a main study tool to understand the structure of our legal system. And teaching jurisprudence is by no means, as I can tell you, the easiest subject in the world for many learners. However, I think this book is excellent. I was very impressed with what I've read of it. It's edited by three people. Again, apologies for pronunciation. Sanne Taekema, Bart van Klink and Wouter de Been. Now, the book's available electronically on the Elgaronline system, and it's also available because Elgar have their main website and an online website as well. Elizabeth and I have given the title for our review of this book, the following title: A Brilliant New Commentary on Jurisprudential Thinking, with its important review of the fact-value distinction. And that actually is the key. Bearing in mind this appears to be one of the areas of great importance within jurisprudence at the moment. One of the keys to the benefits of this book. Let's look at it first of all. There is a hardback. There's the front of it there. Then you can see the spine. Then you've got the back, and you've got some quotes from various important luminaries in legal method and theory. And you've got some statements about where these excellent authors come from. They're based basically in the Netherlands, so that's where the book is emanated from. I'll explain a bit about that in a minute. It's under 300 pages. It's the index at the back there is a short one, and it's on page numbers. You can see the index there. Then you can see right at the back, for instance, there's an article, "The Need for Audacious, Fully Armed Scholars. No conclusions but food for reflection," right at the end. Paragraph numbering there, you'll see throughout there is paragraph numbering and of course useful footnoting. Not too much footnoting, I hasten to add, but enough. It's not a big book, so it's something you can read quite quickly, and I think in jurisprudence that's always useful, bearing in mind Lloyd and the other ones are very heavy tomes and you want something reasonably quick to zip through. There's the front page. Then we get into the various parts. You can see the structure of the book. It's structured into various parts, and each part has a contributor. There are 12 chapters and 5 parts in total, and this is the list of the contributors. There are a large number of people involved in this, some of whom you will know from various publications. Then you have the preface, which explains, and I'm going to mention a bit about it, explains where this came from, where this book came from and the idea for it. Then we go straight into part 1, which is by the 3 editors, explains the introduction, facts, norms and interdisciplinary research. Now, I mentioned right at the beginning something called the fact-value distinction, and I'm going to try and explain that because I suspect quite a lot of people watching this video are not going to really understand what I'm talking about unless I explain in a little bit of detail what we actually mean about the fact-value distinction. Let me come on to that by saying the following. It's always a pleasure to review a new and original piece of research on modern jurisprudential and legal thought, and we have found just the right information contained in Facts and Norms in Law, which has been recently published by Edward Elgar. Elgar, as we know, of course, are very well established as a high quality, top of the range series of research, academic research books, of which great deal of benefit for those doing certainly their bachelor degrees, their undergraduate degree studies, those going for a first, and of course those studying for masters or even a doctorate, because certainly this book, amongst others, will give a great deal of additional thinking to those pursuing their studies. The 3 editors then, Sanne Taekema, Bart van Klink and Wouter de Been, have been joined by 11 other contributors to discuss interdisciplinary reflections on legal method at a high level a high intellectual level for the scholar. Now, 5 years ago, in 2011, Sanne and Bart published a forerunner volume, which they called Law and Method, Interdisciplinary Research into Law. We now have this new work, Facts and Norms in Law, which builds on the original introduction to various interdisciplinary approaches to law. And one of the more fundamental problems addressed originally was what is called the fact-value separation. Now, the editors say that according to some legal scholars, such as Kelson, quote, a distinction can be drawn between empirical sciences that are concerned with facts on the one hand, and normative disciplines that deal with values on the other. So you've got facts on one side, values on the other. That's according to Kelson. And therein lies the beauty of this new exposition, which will, we think, give the student and the jurisprudent much food for thought, especially those scholars seeking a high degree classification who will find this work most helpful for their study programmes. Readers, of course, will know too that empirical sciences, among which are the natural sciences, observe how things are. Always remember your background in probably in your studies for jurisprudence about how the subject has emerged over the centuries. I think it's important to bear in mind, however, that normative sciences such as ethics and legal scholarship are concerned about how things should be. This is where we get into the realms more of philosophy rather than the very palpable legal work that we do as practitioners. We feel that the contributors to this volume have been able to delve into this area of research and produce some excellent points for argument. I certainly found them very useful. I'm sure anybody delivering jurisprudence lectures will find the same. The editors point out that the strict fact-value separation have been rejected by academics adhering to what are called other non-positivist scientific approaches, in particular hermeneutics and pragmatism, which can be the cause of much confusion for those new to jurisprudence and legal theory. Always remember this problem of the non-positivist scientific approaches, which we all had to sort of review, certainly when we did jurisprudence. In order to assist the student, the views of Hilary Putnam, the pragmatic philosopher, are put forward, namely, quote, that knowledge of facts presumes knowledge of values, and vice versa. Knowledge of values presupposes knowledge of facts. Of course, the eminent Dworkin, in his hermeneutical philosophy of law, also rejects a strict fact-value distinction. So the question really is whether it's got any value whatsoever. I think it does, and that's why it's worth reading the book. However, the fact-value distinction continues to raise its head, although Sanne and Bart offer what we would call different determinations. The germination of the book arose primarily because whilst the editors shared a conviction that with the growing popularity of multi- and interdisciplinary approaches to law, their view is that quote, it became more and more important to reflect on this issue precisely because these different positions influence research approaches in different disciplines. Let me conclude by just saying this. The editors intended, and I think they've been successful in stimulating the debate, and they've done so in a thorough and detailed set of 12 essays. Their parting comment is that they hope that the book will inspire the community of legal scholars to engage in interdisciplinary research more often or more fully, and to reflect on its methodological challenges. Again, I think that's a correct approach. And they do so, I think, here brilliantly in Facts and Norms in Law, this book here, as an excellent new commentary for the modern jurisprudent reviewing contemporary legal theory. And as I've said before, it's not an easy area for a lot of people to understand. It's not popular with the students, but I do think this book is easy to read. It's not a difficult book to read, and it does actually has it has case law, which is very useful as well. And it's I think a good book. There's the front again. There's the spine, and then there's the back. And let's just open it in the middle. We're looking here, legal doctrine is a non-normative discipline. That's chapter, let me just find the chapter number for that, part 3, chapter 6. And again, you see the standard structure. There's an introduction as the meat of the argument, and then there's a conclusion at the back. Paragraph numbering and footnoting. And it's looking very, it is written to, I think, to a certain extent, in quite a high writing style. But there again, that's one of the problems with jurisprudence as a whole. The writing style for the essay answer to any question you're put in an exam room, for instance, is always going to expect a fairly high standard of English, and I think you will get the benefits of that from reading this book. I'd like to thank the authors very much, and Edward Elgar, again for producing excellent work for us. Thank you to all of them, and do have a look at our review, which is on the web and in the journals. Thank you. Bye-bye.